Good morning, everyone, and thank you so much for joining us today. Welcome to ESI Spring into Compliance webinar. So we appreciate you for joining us today. We just want to go over a couple of things with you before we actually dive into the meat of our webinar. Next slide, please. So ESI's mission is to simplify the employment challenges of business, and we do that with our three pillars, what we call our three pillars of strength: buying power, efficiencies, and expertise. On our next slide, we'll talk a little bit about housekeeping, if you will. We just want to remind everyone that all participants will be muted during today's presentation. So if you do have any questions, please feel free to submit those questions in the Q&A section, and we will go over those at the end of our webinar. And as always, please remember that we are recording this webinar, and we will send out the resources, including the HRCI certification credits, following today's webinar. And as always, please remember, this webinar is not a substitute for legal advice. We're here to help you, and ESI is always at the forefront of all the changing laws, so that's why we like to do these webinars for you. On the next slide, we will talk about today's agenda. So we are going to update you on the accommodations for pregnant workers. We're going to talk about a new act called the PUMP Act, or Revised Act. And then we also want to bring to your attention some things that are on your radar that you should put on your radar, which include state family paid medical leaves and also sick leaves. We're also going to talk a little bit about some proposed changes for independent contractor versus an employee. And we're also going to touch a little bit about non-competes and what that looks like in the world of litigation and things of that and changes. So on our next slide, I want to talk to you about and introduce you to our first speaker. Her name is Cheryl Zhang. She is an HR manager at ESI. She's been with ESI for over 11 years and has over 30 years of experience in the HR field. And I'm going to turn it over to Cheryl.
Thank you so much, Sheila. Well, let's dive into some new federal protections here. And again, these are going to be for pregnant workers and nursing mothers. So on our next slide, we're going to start with the timelines for these. You'll see that the Pregnant Workers Fairness Act, which we're going to call PWFA, it goes into effect June 27th, and this is going to cover employers with 15 or more employees. The PUMP Act for nursing mothers, that one actually went into effect on December 29th, and employees, however, can't bring a claim until April 28th. So that timeline's coming up, and we just want to make sure everyone's prepared and already taking steps for this one. This is going to cover all employees who are already covered under the Fair Labor Standards Act. And while there's a few rare exceptions to that, you all just need to consider that your employees are covered under that. And if you ever need to, like, maybe do a better analysis or more in-depth analysis, your HR business partners here at ESI can help you. But again, if there's interstate commerce, which sometimes is even a fax machine, you're going to be covered. So we're going to all consider that we're covered for this for now. All right, on the next slide, let's jump into the PWFA. A little bit of background on this one. This kind of isn't new. It's not a new philosophy or new to the employer's realm. The Americans with Disabilities Act already protected employees based on disability. However, pregnancy wasn't considered a disability under the ADA in and of itself. So the PWFA is similar to, if you've worked with the Americans with Disabilities Act before, you'll see some of the same processes, but it's going to expand it a bit to make sure that pregnancy is clearly covered under the new act. So here's how it's going to do that. Specifically, the PWFA is going to require employers to provide a reasonable accommodation to a worker who has a known limitation related to pregnancy, childbirth, or any related medical condition, unless that accommodation would cause the employer an undue hardship. So let's go to the next slide and delve into all that we just said. Excuse me. So when we're talking about how we're going to provide a reasonable accommodation, the way we do that is by engaging in the interactive process. Again, this kind of comes from the ADA. This is a two-way discussion between the employer and the employee. This is very amicable. It's a good faith effort from both parties to determine what's going to be the best accommodation for the workplace, for the employer, for the employee themselves. However, the employee is not guaranteed the accommodation of their choice. So, just for y'all to know, when you're thinking this comes up in your workplace and an employee says they want to, be off Monday and Tuesday and Thursday and Friday of every week, that's not necessarily where it's going to land and what the accommodation is actually going to be after you go through this interactive process. So lots of give and take, and we want to approach this as our good faith effort. So one of the things we said on the previous slide was that, unless the reasonable accommodation causes an undue hardship for the employer. Well, what does that mean? Well, an undue hardship is generally defined as causing significant difficulty or expense to the employer. What kind of becomes difficult with this is that's not defined in black and white in the law. So a lot of where you'll find your guidance on what's going to be an undue hardship is through case law, certain claims that have gone through different courts and been decided, and so now they set precedent for the rest of us to follow. And so that's why if you're working with an employee in the interactive process and y'all come to a reasonable accommodation and you both agree, then you're done. You've done a great job and you can move on with the accommodation. If, however, as an employer, you're not able to do that, you can't come to an agreement, and it is proposing an undue hardship, or that's the route you look like the situation is going to go, you always want to review that with your human resources professional, your HR business partners here at ESI, or an employment law attorney. So just get them involved to help you make that determination if that's the route it's going. Because if there is a claim, the employer is going to have the burden of proof. And so you want to have all of your legwork and I's dotted and T's crossed before you make that claim that it's an undue hardship. All right, next slide. So here are some examples of accommodations. This is actually on the website of the Equal Employment Opportunity Commission. So just to kind of give us an idea, allowing an employee, maybe they get to sit down if their job isn't sitting. I've seen employers who maybe are in retail and the cashiers are always standing. Would it be a reasonable accommodation to get them a stool, a bar stool, and have them sit at their cash register? Yes, that's one. Maybe they drink water more frequently. They have that at their desk when normally it's not allowed. Which why it wouldn't be, we're not sure, but something to think about. And again, these come straight from the EEOC website. Maybe you give your employees more flexible hours, a closer parking place, give them additional break time if they need to eat more frequently. Y'all don't need to know everybody's secret, pregnancy, but that morning sickness, all I could do was eat a cracker like all day long. So if that's the case, giving them extra breaks, maybe to use the bathroom or rest, and then being excused from physical activity. And that can get a little more complex depending on the core duties of the job, and we'll go into that a little bit more. Those are some examples that the EEOC has given us. So let's go next on the slide and talk about what actually the new law requires and what it doesn't. Okay, so we talked about how if the employee has limitations based on their pregnancy, childbirth, or a related condition, what an employer cannot do is fail to make a reasonable accommodation if there's a known limitation for those reasons. And the reason no known limitation is highlighted is because your managers are required to, once they know that this could possibly be related to their childbirth, pregnancy, if there's a limitation with one of their employees, if they know or should have known that they needed a reasonable accommodation, those managers are required by their position to explore that, to bring that up to higher management so that you all can then engage in that process. Sometimes what happens is an employee will bring a claim after the fact. I wasn't accommodated. And the frontline manager or supervisor maybe didn't tell anybody else. So what this means is that we're going to train our managers. They don't have to know every in and out of the law, but they do need to know how to identify these situations and bring them up to higher management or HR. So don't fail to notice. Another thing an employer cannot do is require a qualified employee to accept an accommodation other than what they came up with during the interactive process. So after you go through the give and take, back and forth, good faith effort, interactive process, you want to document the outcome of that so that everyone's very clear going forward. Yes, this is what we all agreed on, and this is what we're going to provide as an accommodation. An employer cannot deny employment opportunities to a qualified employee or take adverse action. And what this means on number 5 is you can't transfer the employee to somewhere that's so much further for them to drive. That's not always reasonable. You can't demote them. Definitely can't terminate them based on strictly needing an accommodation, okay? So you've got to make sure that their employment opportunities and their conditions of their employment remain fairly similar. You can't also require a qualified employees to take a leave of absence. Even if it's paid, you can't require a leave of absence when there's another reasonable accommodation that can be provided. So just make sure you don't jump straight to, this is too much trouble. Just, go be on leave until after you have this baby, okay? So make sure we're really considering the other accommodations before a leave of absence. It's better for everyone to work in general. And of course, if their doctors, though, are requiring that, that's a different story. Okay, and this is so important. This is where we get so many claims. I've seen employers like come out favorably in a claim of, well, they didn't give me an accommodation, but then one of the managers went and retaliated. They harassed the employee because they asked for an accommodation. Maybe, like we said, they demoted them or transferred them, didn't give them opportunities like everybody else. And that retaliation then becomes the claim that you lose against. So just make sure your managers, yourself, that nobody's getting retaliated against. They do have protections under these laws, and so we're gonna treat that and go down the process in accordance with that law. All right, let's go to the next slide. There are some other pregnancy-related protections. So as a reminder, to kind of wrap up on this, PWFA. PWFA applies to accommodations. The other laws that were still out there, Title VII and the Pregnancy Discrimination Act, protect an employee from discrimination. The Americans with Disabilities Act does protect employees from if they have a disability. So let's say they do just need a break or a rest break more often or a closer parking place. However, maybe during their pregnancy, they do become disabled because of another condition, then the protections of the ADA also kick in. So there can be some overlap. And so we just want to make sure we're looking at that. And then for employers who have over 50 employees, the Family Medical Leave Act, FMLA, protects the employee's job for up to 12 weeks. And remember, this can be continuous leave or intermittent, like here and there, and also covers mom for the bonding with the baby, covers the moms, dads, and even in the case of adoption. And then our other presenters are going to talk a lot about state laws. And so just so you all know, this act also has protections within each state. Some of them do, and any state laws that have greater protection than the PWFA, those would come into play. And we'll give y'all a resource afterwards to show which states have pregnancy-related protections. All right, on our next slide, let's move over and start talking about the PUMP Act, which stands for Providing Urgent Maternal Protections. This is for nursing mothers. This amends the Fair Labor Standards Act. So a little background, there's already something in place. Some of you may be familiar with it. So the new act is going to be similar. but it's also going to extend the timeline. It used to be 1 year instead, and now it's going to be 2. And that covers for employers to provide reasonable time during the day for employees to express breast milk, and also to provide a private non-bathroom space. So let's go to the next slide and look at, so that's a little history. Let's look at now what the new requirements are of the Pump Act. So an employer must provide a reasonable break time, we kind of said that, for an employee to express breast milk. That's when they need to. And that's for up to 2 years. The other thing they have to provide is a place other than a bathroom that's shielded from view, so they have some privacy, and free from intrusion, a lock on the door. So one of the things that is explained in the law also is what constitutes the beginning of this 2 years, right? So this is anything that when an employee begins providing breast milk for a nursing child, but also if they need to pump after birth, and that's for any reason. It could be for their child. It could be, unfortunately, if the child was stillborn, or maybe they don't retain legal custody, they give the baby up for adoption. So they don't have to have that baby. We don't want to make that mistake of giving that qualification like, yeah, you gave it up for adoption, so you don't have the rights to this act. That's not the case. Don't make that mistake. And then again, no retaliation. Employers cannot terminate or discipline an employee for requesting the protections under this law. So keep that front of mind. All right, let's talk a little bit more about what these requirements look like in the workplace on the next slide. Who's covered? All right, this is important because you're going to see somewhere employers with fewer than 50 employees are not subject to the requirements of the Pump Act. But that's only if the requirements would impose an undue hardship. And an undue hardship, again, is significant difficulty or expense. So in general, a space for somebody to pump wouldn't necessarily be significant. Of course, there's going to be some rare cases. There's going to be some exceptions, and that's fine. But you still want to get with your HR professional or your employment attorney. And even the law has a listed exception for some folks in transportation, like airlines, trains, workers, things like that. So there are times, but what I don't want anyone to do is go, oh, we're less than 50, we don't have to do this, because you still need to go down the path of considering how would we make this happen in a way that's not an undue hardship. All right, next slide. All right, so are these breaks paid or unpaid? Well, good question. It doesn't have to be paid breaks unless your state or local law or any federal law has a requirement otherwise. So the breaks don't have to be paid. However, let's say that your company already provides compensated breaks. So you pay your employees for breaks, right? Well, you can't now say the employee who's using their break to express milk isn't going to get paid. That wouldn't be in compliance with this law. So just make sure if you're already compensating for breaks, you do the same for an employee who chooses to express milk during their break. All right, now let's say the break is unpaid. If you're an hourly employee, it's an unpaid break, but maybe you get a phone call. Maybe your office is a private place, right? You lock your office door, and then you get a phone call and you start working while you're taking your pump break. That's going to be considered work time. So just make sure if there's any question about it, or if the break was interrupted, somebody needed something urgent, that's going to be considered work time. So either separate them completely so they don't get interrupted by work, or continue to work, and then it can be unpaid. If you think they're going to be in their office and taking calls and checking email, remember, checking email is also work time. Make sure that time is paid. So that's a little caveat right there we need to watch for. And then your exempt salaried employees, they're going to receive their full salary. You don't get to deduct any time from an exempt employee's salary for these breaks. So make sure they still get their full salary. All right, next slide. Okay, when we talk about the space requirements, this is pretty easy. Just convert us, but you can convert a space. You can have a designated place all the time, but it could also be temporary. I mean, if you really don't have anybody, if you don't have a huge staff, and maybe you don't often have people needing to express milk, then set something up temporary. That's fine. It doesn't have to be permanent. And it doesn't need to be dedicated to specifically for expressing breast milk. However, let's say it's a shared space. When the pumping employee needs to pump, then they need to be able to have that room and not have to wait. So just kind of something to consider if it's going to be a shared space. And then, yeah, if you don't have nursing employees at the time, the space can be used for other things. Next slide. And so what are our next steps? How are we going to wrap this up? We're going to review our policies and procedures because remember, this was already in effect. So maybe we already have something, but we need to update it to the 2 years instead of 1. We're going to train our managers so they know what to look for and they don't miss an opportunity to bring things up to their HR or their higher managers. We're going to ensure that a space is available and it's going to meet those requirements, right? It has a lock, it's private, and that they can use it when they have the need to express. And then we're going to ensure that no employees retaliated against. And same thing, the Pump Act, same as the PWFL. There may be some state laws that trump this. So know what's in your state and we're going to help you give a resource for that. All right, and if you have questions, make sure you're putting them in the Q&A. And I'm going to go to the next slide and give this over to our wonderful Kirsten O'Malley, who has over 10 years of experience in HR, and she's an HR business partner with ESI, as well as Miranda Wooten, who is also an HR business partner, has over 12 years of experience. So take it away.
Thank you, Cheryl. And good morning, everyone. As we move into the next section for our webinar, the items that Miranda and I'll be talking about are things that we want you to keep in the back of your mind as you move through the rest of this year. Some of these things are currently in place, some of them are coming up. So again, just kind of be aware. And as you look at the states in which you do business, see if these types of things would apply to you. Next slide, please. So let's start with paid leave laws. It's interesting to note that 86% of full-time workers in the United States had access to some type of paid leave as of March of 2022. This just shows us all how many businesses need to comply with paid leave laws. And what does that mean? Paid leave laws can vary by state, and there's a lot of different scenarios. Is it paid parental leave? Is it medical leave, family leave, bereavement leave, things of that nature? Those paid leave laws can be either voluntary and or mandatory based on the circumstances of the paid leave. There are, interestingly, at the federal level, there are ongoing discussions. You may have seen things in the news about paid leave laws and what the federal government feels should be in place. Currently, as of this moment, there are no federal mandates for paid leave laws. Stay tuned to see if that changes as we move forward. Next slide, please. There are 4 main types of leave. Those are paid family and medical leave, paid sick time, paid time off, and unpaid time off. So let's start with paid family and medical leave. As it states here, this is when people are compensated for extended time that's taken for a qualifying reason. There are no federal laws for the private sector, but many states have their own type of paid family and medical leave program. The second type is paid sick time. These are shorter absences from work where people receive regular wages. These, things like having the flu, or if a family member needs care, that's where paid sick time would come in. Again, there's no federal law guaranteeing access to sick leave, but detect a theme here. Some states and localities have their own paid sick leave laws. Next is paid time off. Paid time off is a combination of separate vacation, sick, or personal days. These are, again, there's no federal law regarding paid time off, but state and some local laws will apply and require paid time off to be offered. Finally, there is unpaid time off. These times away from the job, there is no compensation offered, but in some cases, job protection and continuation of workplace benefits do apply. Family medical leave, so FMLA, is a type of unpaid time off that is mandated at the federal level and applies, as Cheryl mentioned, to employers of 50 or more employees, with some other requirements as well for the employee. Some states have additional unpaid time off protections, so it's important to pay attention to your to the laws in the state in which you operate. Next slide, please. Here is a visual representation for the United States of paid family leave laws. You'll notice the darkest green color. Those are states with active paid family leave laws in place as of now. Basically, you know, the east and the west coast of the United States is where those states are. The lighter green color is states that have paid family leave laws that they have those programs, but they are not currently active, so they are upcoming. Illinois is the most recent state to have signed that into law, and we'll talk in just a moment about when that starts happening. The rest of the states noted here, the lightest color, including Alaska and Hawaii, do not have paid family leave laws in place. You'll see that's the majority of the states within the United States. Next slide, please. In 2023, there are going to be a variety of changes that are coming to the current paid family medical leave standards. The states that are listed here, there are 11, and they are going to see some type of change during the rest of this year. Many of these changes are going to be changes to either the contribution or to the deductions that are occurring. For those states where there's a 2023 date involved, those dates are listed here on the slide. There are 5 programs that are beginning in 2023. And again, these are just general changes that are coming to these states as we continue through the rest of this year. Next slide, please. These states have proposed PMFL legislation on the books. As I mentioned just a moment ago, Illinois has now passed theirs, so they are in the middle step between these two. So watch if you do business in any of these states for any of these laws to pass, so that you can make sure that you're in compliance with any new legislation. And your HR business partner will be staying on top of that to help either if you set up business in one of these states as a new business, or if the regulations change within those states. Interesting to note that in July of this year, Vermont is going to launch a voluntary paid family leave program for state employees only. Their goal within Vermont is to make that program available to all workers in 2025, but that's a little bit down the road. So we'll just stay abreast of that. Next slide, please. This slide, which we will be sending you after the webinar is over, contains links to the specific state leave websites. What I would suggest to you is that if you do business in any of these states, it is incredibly helpful to link over and see what their state website looks like. They provide a wealth of information, including, but not limited to, any forms that are required, the specific deadlines for compliance with those leave laws within the state. Those websites are updated very frequently, ideally. And so it is just a really good idea to have this information handy should the need arise. So again, this resource will be provided to you after the webinar is complete. And we would suggest that if you do business in one of these states, that you take a few moments, link over and see what they have to say. Next slide. I will turn this over to Miranda to talk to you about paid sick leave laws.
Thank you, Kirsten. Yes, so I'm going to talk a little bit about paid sick leave laws. So this map just represents, if you look at the blue, so that's kind of represented by Colorado. These are states that currently have paid sick leave laws in place. If you look at the states that are lighter blue, such as California, these are states that have state level and then cities within the state that also have paid sick leave laws. And then the dark blue, New Mexico, Pennsylvania, these are states that do not have statewide. It's only at the city and county level. So within the state, so I believe New Mexico has one city within the state, and then Pennsylvania has a few that have cities, counties wise, paid sick leave. And then the rest are the white states, and they currently do not have any paid sick leave laws in place. And so you can kind of see a little bit mirrors what Kirsten already showed us on the paid family leave. It definitely is concentrated on the West Coast and then on the East Coast. So I definitely think, you know, it's kind of starting outwards and kind of going into the middle. So next slide, please. So here are just the states listed out. So there's currently 20 states with paid sick leave laws, either at the state level or the city county level. Next slide. So for 2023, there hasn't been a lot of changes to paid sick leaves. 2 states, California and New York, made changes. They both went into effect January 1st of 2023. So starting with California, they changed the definition of a family member to include a designated person. So the person designated does not need to be blood or family relationship with the employee, although it should be the equivalent of a family relationship. And then New York, January 1st, also expanded leave to provide for employees caring for their siblings. Next slide. So in addition to paid sick leave laws, there's kind of some additional leave laws that came into play in 2023. So starting with California. So they have a bereavement law. So employers with 5 or more employees are now required to provide 5 days of paid bereavement leave. And this needs to take place within the first 3 months that the employee experienced a loss. And then in Illinois, so this will go into effect January 1st of 2024. So Paid Leave for All Workers Act, and this will grant employees a minimum of 40 hours of paid time off per year. And this just needs to be noted that it can be used for any reason. So this is not a paid sick leave. This can be used for personal, sick, vacation. This is kind of for any reason. And then Maine this year passed a law that vacation payout. So all employers with 11 or more employees must pay out all accrued unused vacation wages. And I would just like to note, this is not a new type. There's many states that already have a vacation payout law. So it's just good to kind of be familiar with where you have employees and understanding the laws in each of those states. Next slide. So I wanted to just put this in here, really just to show, and this relates to the paid family medical leave as well, but no laws are created equal. So these laws vary tremendously from state to state, cities and counties. The accrual rates here in Colorado, it's 1 hour for every 30 hours worked up to 48 hours. In New Mexico, it's up to 64 hours. So they definitely can change. So it's definitely, if you have one policy, it's not going to necessarily transfer state to state. So the maximal accrual difference, which employees the law pertains to, reasons leave can be taken. Again, I know here in Colorado, it's paid sick and safe leave. So it's not only for sick reasons, but if any domestic violence issues come into play, that they're also eligible to take the leave. Notice requirements, documentation that's required, and posting requirements. So again, you know, we're keeping an eye out for this stuff, but as more and more employees are remote and going into different states, and different states have different laws, it's good to check the state websites. As Kirsten said, you can reach out to us. I do currently have a client that they have employees in 20 different states, and they choose the policies that's the richest and kind of does that as the overarching policies. But that may not work for everybody. So we're here to definitely help. Next slide, please. So independent contractors. So I'm just going to briefly talk about a new proposed additions to these regulations. Next slide. So back late last year, October 13th of 2022, the Department of Labor published a notice of proposed rulemaking. And this proposes to revise the department's guidance on how to determine who is an employee or independent contract. So the previous rules were published back on January 7th of 2021. And this new proposal is to rescind that rule. They want to replace it with an analysis for determining employee or independent contractor status that is more consistent with FLSA. So the Department of Labor, they believe that its proposed rule would reduce the risk that employees are misclassified as independent contractors, while providing added certainty for businesses that engage or wish to engage with individuals who are in business for themselves. If an employer misclassifies an employee and calls them an employee or calls them an independent contractor, misclassifications can result, can bring companies and organizations to class and collective actions and expose them to significant liabilities. So there is a likelihood if you classify someone as an independent contractor and they really should be a W-2 employee, that you have to pay back, overtime, unemployment, work comp. So it's very imperative that employers are not misclassifying people as independent contractors. So under this new law, it's going from kind of a 6-factor test or a 5-factor test to a 6 factors. And so what they propose is to look at to see if this individual would qualify to be an independent contractor. That the first one would be the opportunity for profit or loss depending on managerial skills, the investments by the worker and the employer, the degree of permanence of the work relationship, the nature and degree of employer control, the extent to which the work performed is an integral part of the employer's business, and then finally, the worker's use of skilled initiative. So that this is just the proposed rules. Next slide. So on this slide, I wanted to just illustrate on the left side, this is the current 2020 rule. So this is the one that's kind of in effect. And then on the left side, this is the proposed 2022 rule. So on the left side, it's a 5 factors I had mentioned. And the first 2 factors are weighed more heavily. So the first two factors are the nature and the degree of the worker's control over the work, and then the worker's opportunity for profit or loss. So currently those 2 are weighed more heavy than the other 3 factors. Under the proposed rules, they have 6 factors now instead of 5, and everything is going to be weighed equally. So economic dependence remains the ultimate inquiry for determining whether a worker is an independent contractor. However, the new proposed rule expands the analysis and requires consideration of all factors with equal weight. And the hope is to make it harder for independent contractors' classifications to survive legal challenges. So ideally, they're hoping that some of this more strict rules and looking at things equally will help prevent misclassification, therefore, legal actions against employers. So that is all I have on independent contractors. I'm going to turn things back over to Cheryl to talk about non-competes.
Perfect. Thank you, Miranda. So we can go to the next slide. As some of you know, you use these in your business. Non-compete agreements is something that your employees would sign, say, for example, when they were hired, that they're agreeing based on not to work for a competitor when they leave you. That's based on geographic area for a certain length of time. And it is established to protect your proprietary client list, that kind of thing. So what's being proposed now by the Federal Trade Commission is to prohibit employers from engaging in non-compete agreements and even from enforcing ones that are already in place. So this has not become law yet. It's out for some public opinion, for people to submit, to give input. But we wanted y'all to know what's out there. I do know some of us, especially maybe with our sales folks, have used these in the past, and want you to know this could be coming down the road. We do expect it's going to be challenged. And in fact, the fact that the Federal Trade Commission is the one that's proposing it instead of, say, the Department of Labor, which we normally see in employment law, is the way they've worded it, is trying to give the FTC the domain to actually enact it, and that's even being challenged. But just so you know, in case it comes up later, we'll keep an eye on it for you. We'll let you know, but you could even have to rescind your existing non-competes, providing notice to existing employees who were covered under one, or even former employees. So again, we do expect some significant challenges. Don't mean to scare you, but we're here to keep y'all informed, and we wanted you to know that this is something that could be on the horizon. All right, I am going to give everything back to Sheila, our wonderful moderator, and to answer and ask any questions that we have. You can go to the next one.
Thank you so much, Cheryl and Miranda and Kirsten. Thank you so much for your insight and your wonderful wisdom today. We appreciate it. We do have a couple questions in the chat. Angela asked, is the interactive process an ongoing process? I imagine as a pregnancy progresses, accommodations needed may need to change as well.
Yeah, I'll field that one. That's a great point. Things could change, and you definitely want to be flexible and revisit that interactive process anytime that you need to.
Definitely. Amanda has a question. Would the state PMFL apply only if the employer has more than 50 employees who work within the state, or at least 50 employees in the company overall?
So I'll jump into that one. Again, great question. It really does vary by state. So there is not a hard and fast rule. The 50 that you're referring to could possibly be with the Family Medical Leave Act, but the state regulations vary widely from one employee and up. So you really want to stay in touch with your HR business partner and make sure that you're following guidance for the specific state.
Definitely. Great questions. We have a couple more. What if an employee comes to me and says, I want to be an independent contractor? How would you handle that?
Yeah, I'll take this. So independent, the relationship that needs to be determined by the employer. So we should not have employees driving those conversations, because ultimately the employer is going to be liable for that. So we want to make sure, I mean, because employees want to come up, they don't want to pay taxes. They think, hey, I don't have to pay taxes, I can be an independent contractor. It doesn't work that way. So I definitely would, as the employer, look at those 5 different factors in when making that determination.
Great. Thank you, Miranda. One last question looks like we have coming in. I have some women in a maintenance position and we don't have light duty. So if I cannot accommodate the request for accommodation, how do I accommodate the request?
Okay, I can help with that. Of course, it's going to depend on the specific scenario. But let's just take some examples. If you've got someone doing maintenance, and maybe their accommodation is that they need to take breaks, or maybe they need some different equipment, or maybe it's just, let's say they need help lifting things. Okay, we'll go with that. So they can't lift quite as heavy as they used to, and there's other maintenance people on your staff. So you using someone else to help with parts of someone's duty is reasonable. That would be considered reasonable. Now, let's say they needed somebody to take care of a task that's like 80% of their job. Well, then you get more into, could that be a hardship? And one of the words you want to think about when you're thinking about, is it a hardship or not, is significant difficulty or expense. Something that costs a couple $100, that's not going to be considered significant. And like in this scenario, somebody having to lift things. Okay, if the lifting is a couple times a week, maybe once a day, having somebody help with that, that would not be considered significantly difficult. But again, if it's 80% of their job and maybe they unload FedEx trucks and they can't do any of it, then that kind of becomes a different scenario. So we're going to look at, is it a significant portion of their job, and significant expense is going to help us kind of make those determinations.
Definitely. Looks like we had one more question come in. Executive Order 13706 establishes paid sick leave for federal contractors. Just to confirm, there are PTO laws that apply to employees covered by a federal contract, correct? Executive Order 13706, these apply to our employees if we are working at a federally funded project. So I guess basically the question is, I think paid sick leave law versus the federal government 13706 executive order. Does anybody want to take that?
I'll take that one. So the answer, Lisa, is the short answer is yes, because that would take precedence over any local paid sick leave requirements. Anything mandated by the federal government at that level would take precedence. So as Miranda pointed out, sometimes the simplest way to do that is to look at the most overarching policy and then apply that to everyone regardless. But that can be looked at, I would suggest speaking to your HR business partner to ensure that whatever you have in place, number one, keeps it as simple as possible, but number two, meets all those requirements.
Great. Got a couple more questions. Would a transfer for a pregnant worker be reasonable accommodation? If so, would the pay need to remain the same? That's a good question.
Yeah, I got you. So a transfer can be a reasonable accommodation. What you want to watch for, though, is, let's say you transfer them to a different position. Yes, generally the pay would need to remain the same, because that would, if their pay dropped, that could be considered adverse action and would not, but also think about if you transfer somebody and then maybe they don't have as much time in the position as someone else who didn't have to be transferred. Now maybe they're not on the same footing for promotion. While it's a roundabout way, that still definitely has been called into question in the past in case law. And so you want to make sure that you're not affecting their career potential, because then you're outside of compliance with the law. So put a little thought into that, work with your HR business partner. Good question.
Definitely. Should there be a time limit on independent contractors? And are there any issues with having W-2 employees and independent contractors in the same position within a company? Ooh, that could raise a red flag.
Yeah, I mean, as far as like the time limit, I don't think there's like a set time limit, but typically an independent contractor is working on projects. So I guess there can be an indefinite project and they're kind of working on it forever, but I think you really need to look at some of the other factors as well. But there's not a set time limit that you can only use this individual for 6 months or 12 months or something. Because I know there's times that, maybe an independent contractor is doing IT type work or something for the company. So that's kind of an ongoing project. Which is why there are some other factors that they take into place. It's not just one factor. Yes, they meet this factor. They are an independent contractor. And as far as the issues with W-2 employees and independent contractors, as Sheila kind of reacted, I think that, that would be something I would definitely have you look at and speak with an attorney for, because it could rate, like, why is, this person working as a W-2 employee and also I think there maybe could be scenarios where this employee is maybe a maintenance person for the company, and then maybe they also have their own business doing something, and that may come into play, that would be also an independent contractor. Typically, independent contractors need to be paid under a company. So we're not paying independent contractors under, you know, your actual name. But that's something I don't 100% know. I could do some research on, but I definitely would speak with an attorney to make sure that doesn't bring up any red flags why you have these two different classifications.
Yeah. Looks like we may have the last question here. If you currently have a paid 6-week maternity leave, can a father request paid paternity leave as well?
I'll take that one. This is Kirsten, and I just wanted to also remind everybody with independent contractors that, and versus W-2, part of the other issue there is access to benefits. So if you are, you know, statutory benefits and those types of things, sometimes your W-2 employees, those are provided to them. Independent contractors, that's part of the requirement, is that they are not. So if you have somebody, you know, this as the same position, some people IC and some people W-2, that could also raise a red flag. So I just wanted to throw that in there real quick. But to the question here about paid paternity leave, that depends on the state in which you operate. And if there are paternity leave laws in that state, or also for your individual company, if you have a paternity leave policy, but you are in a state such as Texas that does not have a required paid paternity leave legislation, then all those factors factor in. So unfortunately, it is not a straight shot answer. Those variables come into play.
Definitely. Well, it looks like that's all the answers. That's all the questions we have right now.
I think there's one more, Sheila.
Oh, is there?
If we
No.
still have time. Yeah.
No. So as I want to thank everyone for joining us, and thank you very much, ladies, for your time. We appreciate it. And as always, thank you for attending our webinar. You will be receiving a survey today. And of course, we thought we did a fantabulous job, but of course we need your input. We want to know what you want to hear from us. What did you think? So please fill out our survey for us. We would really love your feedback and love to hear how we can make ourselves better, and also our informative sessions like today better for you. So definitely fill out that. And if you have any questions, please feel free to email us at hr@eesipeo.com. And that should wrap up today. And as always, we will be sending out this information here shortly, with the recording and the webinars and the HRCI certification here shortly. Thank you very much, everyone, for your time, and have a great day.